Hello and good afternoon, good morning friends. Welcome to the CEC-UGC live lecture. Dear friends, today we would be talking on one of the most serious topics, though we have discussed in detail in our previous session. We have discussed prevention of sexual harassment at the workplace. Dear friends, as we are seeing that the crimes against women are increasing and to control those crimes, it is our foremost responsibility. So dear friends, taking the series forward on organizational behavior, today also we would be talking on prevention of sexual harassment at the workplace. And for this discussion, we have once again with us in our studios Dr. Namita Rajput. Dr. Namita Rajput is principal in Sri Aurobindo Evening College, University of Delhi. Dr. Rajput is a prolific professor who believes in giving more and more of the information through her experience. So let's welcome her and let's discuss the topic in detail. Hello ma'am, welcome to the EduSet lecture.
So good morning friends, we have today a very pertinent topic, although we discussed last week also, but there are certain more provisions which to be addressed, so we'll be taking in this part of the lecture. So starting with the sexual harassment as we already discussed is not a women thing, it is not a passing fad, it is not to be something which is to be joked upon, it is a cause of paranoia and fear. It is a legal requirement to prevent, prohibit and address this issue at the workplace. We discussed about the Bhanwari Devi. She showed the extraordinary courage about the conviction and the commitment to reduce the workplace harassment. Now we discussed about the Vishakha Guidelines which are issued by the Supreme Court of India judgment in 1997. This is Vishakha versus the state of Rajasthan. In the absence of enactment of the law to provide for the effective enforcement of the basic human rights of gender equality and guarantee against the sexual harassment and abuse, we laid the guidelines and the norms specified herein for due observance at all workplaces or other institutions until a legislation is enacted for this purpose. So overall we have discussed the Vishakha Guidelines and what are the particular acts which tantamounts to the sexual harassment, and we discussed few cases about the Delhi rape case also which happened in 2012, and we discussed about the advent of the law, that is the statute which has been discussed here is applicable to whole of India, and it is only for the protection of women at workplace. Nowadays basically we are talking about the basics here, that is the preamble of the act to provide the protection against the sexual harassment of the women at workplace and for the prevention of redressal of complaints of sexual harassment and for the matters connected there with the incidental thereto. Now basically no women shall be subjected to sexual harassment at workplace under section 3 subsection 1. Understanding the basics of it, we discussed in the last week what is the sexual harassment, what is a workplace, and what is basically the act which is called as the aggrieved women. Now all women who are working at the workplace and who suffer this kind of an act, they are called as the aggrieved women, whether their women is under the regular employment or ad hoc employment or temporary employment or directly or indirectly engaged with the contract, and basically they are working for the remuneration, and it could be a co-worker, contract worker, prohibitor, trainee, apprentice, visitor. All covers the working women in the dwelling or the workplace also. Now what is a workplace? We also discussed last week, and this discussed about the private organizations, public organizations, government, semi-government, private, even the houses, the hospitals, etc. Now the workplace also is extended to the office parties, offsuits, outbound training, client meetings, training sessions, travel of the office purpose, and any place where one visits in the course or the due course of the employment. Now what is a sexual harassment? We discussed in detail in the last lecture. So just a recap of what we did so that we have a connection in the further provisions which we are going to discuss. Now sexual harassment is all about bullying or coercion of a sexual nature or the unwelcome or inappropriate promise of rewards in exchange of sexual favors. In most of the modern legal contexts, sexual harassment is illegal and is basically a gross violation of the women's right of equality and dignity. So we discussed about the sexual harassment under section 2 subsection 9 of the act, and basically the sexual harassment includes number 1, the physical contact and advances which they are trying to make, a demand or a request for the sexual favor. sexually colored remarks, showing pornography, other offensive, derogatory pictures, cartoons, etc., or any other unwelcome verbal, non-verbal conduct of sexual nature. Now, basically, the women has got a dignity and respect, and as a matter of fact, any kind of sexual harassment should be prohibited. And for that matter, it is very important for all the women to know what sexual harassment is all about, how this can be controlled. That is, know yourself, protect yourself is the message of today's lecture. Now, there are different forms of the sexual harassment which they have to undergo. The first is the quid pro quo, and for this it implies the explicit promise of a preferential detrimental treatment in employment, and this is about express or implied threat about her present or future employment status. That is, if she says no to sexual harassment or the sexual advances or asking of the favors, of course she is treated as a toy in the organization, and if she says no, this is also a kind of a bad act for the organization, which is definitely not in the health of the organizations. And of course any kind of unsavory remarks, gender-based insults, sexual remarks, forcible, physical touch, molestation, and abuse of the authority. So in short, we say that workplace harassment is all about sexual in nature, subjective experience, impact not on the intent matters. So here a woman is asked about what she is not ready to do, but yes, because of the personal pressures from the family to feed the number of the members at the home, and of course about earning her bread and butter, she is forced to get herself involved in all these acts, because if she says no to it, then she has a problem as far as her employment is concerned. So definitely all these things are very bad in nature, and women always feel humiliated. She is unsafe, unhealthy, discriminatory, career limiting, and other causing adverse circumstances. So they are all basically, the women is all apprehensive about it, and she never says no to it. And we must, all of us, know that any kind of a sexual harassment at workplace is a very important criminal offense, which should be at any cost controlled, and it should be uprooted in all the cases. We discussed about the Indian Penal Code for a few provisions in the last lecture also. The first was the 354 section, which says the assault or criminal force to a woman with intent to outrage her modesty is definitely not allowed. Then we discussed about section 350A of the Act of the Indian Penal Code, which says that the physical contact and advances which are unwelcome and explicit sexual overtones, etc. Then we discussed about section 294, which is obscene acts or the songs. So this is also punishable under the act. The punishment includes not only the term, which may extend to 3 months, but with a fine or with both. Then we discussed the Indian penal provisions of section 509, which says the word, gesture, or the act intended to insult the modesty of a woman is also punishable with the criminal liability, that is with the fine and with the imprisonment or with both. Then we discussed about the section 354 subsection B, which states that any kind of an act which forces a woman with the intent to disrobe her, this is definitely a very shameful offense. Then we discussed about section 354 subsection 3 of the Criminal Act, which says voyeurism, that is the victim consents the capture of the images or any act, but not to their dissentiment of a third person, and such images or the act is disseminated, and of course it is an offense under this act. Then we discussed section 354 subsection D of the Indian Penal Code, which states about the stalking, that is you are continuously bothering a woman in terms of what she's doing on social media, where is she going, what is she doing, so you're tracking all the activities. So this is also a punishable offense, which may extend to even the imprisonment to 5 years, or with fine, or with both. So in all cases we have to see the intensity of the act and what kind of acts are important to be controlled in this regard. Then we say that civil remedy under the POSH and the criminal remedy under the Indian Penal Code. So we can always observe that the sexual harassment is not only inviting the civil liability, but also criminal liability, which is definitely more intense and grave. Then now we are coming to the most important section, that is section 3 of this Vishakha Guidelines, that is the prevention and prohibition. Who is responsible and accountable for prevention, and what is the role of the workplace in prohibiting and how? The employer, as a matter of fact, is the custodian of the workplace, and he must create an environment which is a sexually free environment. Now, who is an employer? Employer is definitely, it could be a central government employee, it could be the local government, it could be a head, it could be a dwelling house, etc. Then definitely there are certain duties which were of the employer to take care of, that the women must work in a safe environment at the workplace, and we must organize the workshops time and again, so that there is a complete information which is disseminated onto the women, that is, in case she is a victim of any kind of a sexual harassment, the things could be controlled. So securing the internal control committee of the workplace must be in order, and there is a specific criteria to become and to be a member of the internal complaint committee, that is the ICC. So the employer must create and communicate a detailed policy in this regard, and of course they must ensure that the orientation and the awareness is there on this issue to all the women who are working in that organization. And of course they should prepare the annual reports to be submitted to the director's office, and it is the employer responsibility to prevent or deter the committing of any act of sexual harassment by means of creating a proper working conditions, ensuring the women are not the sex objects in the organization, and of course they must ensure that no employee or the third party will outrage or insult the modesty of a women colleague, and of course establishment of the complaint committee, that is the ICC, and the LCC, that is the local complaint committee, must be in order. Now we must understand the provisions of forming this internal complaint committee and of course this the local complaint committee in this regard. Now the members to hold an office should not be exceeding 3 years, and the ICC for each branch and office, if they are having a multiple branches, it should be separate, and of course it is considered as a quasi judicial body with the powers to even give the summon and enforce the attendance. It calls for even the evidences and the documents in this regard. So internal complaint committee, there is a constitution which is in the written order, that is the chairman, 2 members and the members, as we discussed in the last lecture, and the 50% of this committee has to be women, that is the chairman, member, 2 members and ex officio members, and the complaint committee should be thoroughly prepared. They should know about the act, policy or relevant service rules, because they are the judicial ex officio body. They must determine the main issue of the complaint. They must prepare the relevant interview questions. They must conduct the necessary interviews, ensure the parties are made aware of the process, and their rights and responsibilities must be well known to them. Whatever they do, they must be impartial and listen to all the complaints in deep. Try to have the evidences of all the incidents which happened, so that a right kind of a judgment can take place. Now coming on to section 3, a very important part of the guidelines to prevent the sexual harassment at the workplace, which is called as a communication. That is, education and awareness is the key. If a woman is educated enough, if she is aware of the guidelines which are for her protection, it is very, very important. Definitely about the policy, employer must create a policy which prohibits the sexual harassment at the workplace. They must provide a detailed framework for redressal of the complaints, and the policy must be communicated to the people at large, specifically the female employees of the organization. Now they must carry out the awareness and orientation of all the employees in this case, because there is one party who does the sexual harassment and the other to whom the sexual harassment is done. So it is very important to understand that both the parties who are involved in the sexual harassment act, they must be aware of the policy and what are the consequences, what are the deep repercussions if any of this act happens. So now coming on to section 4 of the guidelines, that is the redressal. So this is very, very important to understand that what is the complaint mechanism, what is the dais where the women can go and complain, how their voices will be heard. So there is a detailed mechanism in this regard of the complaint mechanism. So let us do this in detail. Any aggrieved women, they must make a complaint in writing of the sexual harassment at workplace to the complaint committee within a period of 3 months from the date of incidents in which the series happened. The time limit may be extended for another 3 months if the complaint committee is satisfied with the reasons of non-filing of the documents. If the woman is unable to make a complaint in writing, a CC to provide the assistance. So in this case, in certain cases, the women, they are afraid of doing the complaints. But it is primarily the responsibility of the complaint committee to assist her in drafting her complaint, and they should assist in every manner in terms of writing, in terms of the mental support to the women, and in terms of that she should not be taking any kind of a rubbish on her. So who can make a complaint is very important. It is the women herself who can do, and in case of her mental incapacity, her relative, her friend, special educator, qualified psychiatrist, psychologist, guardian, and she is receiving a care from, and any person who has informed about the incidents with the written consent of any of the above. So you can see here that there is a lot of leverage which is given in terms of even the complainee. That is, even if the woman is under a trauma of the Sexual Harassment Act, then there are certain other people who can assist her in drafting a complaint and giving a complaint in this regard. Now, of course, in case of the physical incapacity, any of her friend, co-friend, in case of she's undergoing a treatment, her psychologist, psychiatrist, they can always give a written complaint that the woman has been under trauma, and this is her complaint, and this has she has been a victim of all these persons. And in case of a death of any person who has informed about the incidents with the written consent of her legal heirs, in case of any of the person, any person who has informed about the incidents with the written consent of the women is unable to make complaint due to death or physical or mental incapability, her legal heirs, person authorized to make, can give a complaint in writing. So here it is also a very important thing to understand that if she is unable to do it, then of course the mechanism gives us a quite good number of people who can be assisting her in giving the complaints in writing. Now the complaint copies which she has to submit is 6 in number by the aggrieved person, should not contain all the material and relevant details concerning the alleged sexual harassment, which includes the name of the contravor, the complainant, the date, time, location, working relationship between the parties, name and address of the witness, if any. In most of the cases, specifically when you're talking about the sexual harassment at workplace, the witness are not there, because normally the people find those opportunities to do such kind of a bad act, that is a sexual assault, where nobody is present, so that there is no witness and they can just do away with the bad acts which you have done. Now coming on to the copies which have been submitted either by the women or by her legal heirs or by any person who is authorized to do that, in this case which we have already discussed in detail. Now is the time that on receiving such a complaint, the chairperson will inform the other members of the committee that we have received a written complaint of the sexual harassment at workplace. Now the internal complaint committee shall investigate and submit its report containing the findings, recommendations along with the relevant documents. And in conducting the inquiry, a minimum of 3 members of CC, including a chairperson, to be present. Upon receipt of the complaint, the review of the complaint, it has to be having all the information. The conduct and respondent was towards the complainant is improper, and if from the sexual harassment at workplace, the incident occurred in the workplace or any other location, any event related to work. That is, sometimes the women has to go out, meet the clients, attend the meetings, etc. So it is not, it is very important to understand that where the incident happened. But yes, that incidents must relate to the workplace or must be relating to the office work, because this is very important, and it is very relevant also that everything is connected with the work or with the workplace. And of course, the sending of the complaints with the respondents within 7 days of the receipt to such respondent within 10 days. They have to meet up with the complainant for any settlement or conciliation. Now, whosoever is a member of the internal complaint committee, after they have received the complaint, they must make all the arrangements to make both the parties, so that if there is any agreement or conciliation which can take place, they must try for it. Now, conciliation is all about initiative of the conciliation process in the form of verbal warning, counseling, education, and appoint a neutral conciliator to resolve forwarding the finding, conciliation, resolution to the employer, and the choice is of the complainant. Now, in this case, if a woman is a victim of the sexual harassment, sometimes the conciliation is enough because the incident is not that grave and you do not want any kind of a ruckus or loss of reputation of the women and of the office, etc. The reasons could be any, but yes, if the complainant is ready for the reconciliation, then of course a kind of a counseling session, a kind of education, a kind of a verbal warning is enough to take care of all these things. But yes, here we have to see the choice of the complainant. If the complainant is happy about it, then of course we can go ahead with the proceeding. Otherwise, it can also include the other aspects also, which are more legal in nature, and of course they are more grave in nature. Now, coming on to the second part, that is the inquiry. Once the sexual harassment complaint has been received, now the internal complaint committee must inquire, that is the initiative of the inquiry, the interview of the complainant, respondent witness, listing of the events, the fact finding, and confidentiality and impartiality is the key of this organization committee, which is the prime committee of the organization, that is the internal complaint committee. No proceedings, nothing of the minutes, and confidentiality is maintained throughout so that a right kind of a judgment can take place, and nothing, the other things which can play a significant role, they are not biased in this regard. Now, the inquiry process. We should follow a principle of a natural justice, that is the order ex parte, and terminate the proceedings if the complainant or respondent fail to be present for 3 consecutive hearings. The legal practitioners are not permitted, confidentiality has to be maintained, and the committee must adhere to the rules of the natural justice. There are 3 important rules to be observed by the committee: hearing, play safe, play fair, and the reasoned orders. Now, of course, the nobody can be condemned without being heard. So, even if you have not heard, you cannot blame anyone, because hearing is very important so that you have end-to-end information which is complete and comprehensive, so that you can have a strong conviction that whether a person is a convict or not. Followed by a fair play, that is the judge must be impartial and act fairly and in good faith. And the reasoned orders is the third part. Now is the interim measure to prevent ongoing sexual harassment at the written request of the women or the event otherwise. The complaint committee may recommend restrain the respondent from reporting on work performance of the aggrieved women, writing her confidential report appraisal, supervising her academic activities, transfer the complaint or respondent, and place complainant or respondent on leave. So there are certain recommendations which are also a part of this in case of all allegations are proven. The first is the service rules to be followed in case of misconduct. These recommendations are very, very important and pertinent. So a lot of care has to be taken in this case. That is, if the allegations are proved, these are the recommendations. The first we have talked about already is the service rules to be followed in case of any misconduct. Disciplinary actions, that is written apology, warning may be given by the person who has committed the sexual harassment, repayment, withholding of promotions, withholding of any increase in increments, counseling sessions, community service, termination from service, financial damages, additional recommendations to address the underlying factors. So it is again a matter of recommendations that whether the allegations are proved or not, which of the allegations are proved, how they are proved, the intensity of the incidents, the graveness of the incidents. So many factors have to be taken into account. If the allegations are proved, then of course you have to take a disciplinary action. If the misconduct is proved, again you have to take an action in this regard. The losses which are done to a women are not repairable. But yes, these kind of recommendations, if adhered to, can also prohibit the other people to indulge into any kind of alleged sexual harassment at workplace. Like if you can stop the promotion, you can stop the financial any kind of a bonus to them, and you can terminate their services. You can also give some kind of damages or fine to them. the civil as well as the criminal liability is also part of this. So you must give a lesson to the others also, that in case you continue doing all these activities, these are the repercussions and these are the end results if you continue doing the sexual harassment at workplace. Now sometimes as the law is in the favor of women, but there are certain other cases which we are also reported that there is no incidence of this sort, but the women is under a position to use her position in a very negative way also. That is, the complaints could be false, it could be malicious also. So we have to see the other side of it also, that it could be a wrong intention of the women also to indulge and engage a man to settle her personal scores on some other grounds, but there is no sexual harassment incident at workplace with her, but she is just reporting a false and a malicious complaint. So you have to lift the veil, you have to see what are the real intentions, whether the incident actually happened or not. So where the internal committee arrives at a conclusion that the allegations against the respondent is malicious, aggrieved women or any other person making the complaint has made the complaint knowingly it to be false, or the aggrieved women or any other person making the complaint has proved any forged or misleading documents, it can recommend to the employer to take action against the women or the person who has made the complaint, as the case may be, in accordance with the provisions applicable to her or him, provided further that the malicious intent on part of the complainant has to be established after the inquiry in accordance with the procedure prescribed before any action is recommended. So the internal complaint committee comes to this conclusion that any witness has made a wrong statement, it may recommend the employer to take action against such employee as well also. So here very important aspects are revealed here, that in case the sexual harassment is true in nature, so definitely the things, the redressal which we have already talked about must be taken and necessary action must be taken, so that it becomes an example of the others, so that they get prohibited in this regard and they are not doing the sexual harassment at workplace. But yes, on the other side of it, if the women is doing all these activities under certain malicious circumstances, or the report is false and is malicious, then of course a strict action must be taken against that women also, because we have got no right to damage or have a wrong concept about a person who is actually not doing a sexual harassment, or you do not have a right to jeopardize the image or the reputation of any other person who is actually not into a sexual harassment cases. So in this case we will be talking about the timelines. So now we have received the complaint from the complainant, that is the complaint mechanism has to be addressed nicely and in detail, so that every woman knows that if she is a victim of the sexual harassment at workplace, how she has to move on. So we have discussed that if she is under a trauma, and she cannot write a written complaint, the complaint committee must, but she has to visit the complaint committee in this regard, or they have to talk about the sexual harassment which she has been a victim to with her family members if she is not able to come herself. But yes, in any case, the complaint committee has to be informed about any kind of incidents which has already been taken place with her, and that sexual harassment must be connected to the work related to the office. It could be going to a meeting, it could be any place where she is supposed to go and is a routine part of the organization's work also. So all these parameters have to be done in detail. Now is the responsibility of the complaint committee to inform the other members of the committee that we have been given this kind of a written complaint by this women. So they inform everybody who is a part or parcel of this committee to take care of the matter which has already been reported by a woman, aggrieved women in this regard. So the first meeting is to be held immediately within a reasonable time, but not later than 7 working days of receiving the written complaint of the aggrieved women. So here the timeline is very, very important, because as the incident had taken place, the woman is already under a state of her traumatic conditions and she is unable to perform her, the routine work. So it is the prime responsibility of the internal complaint committee, which is definitely a judicial quasi body, which has equal power to even ask for the evidences, to even issue the summons in this regard. So what is to be done here is that if the matter is reported to the committee, the first meeting of the internal complaint committee, which is definitely taking care of all these issues that is the sexual harassment at workplace, it must be held in the 7 working days of the receipt of that particular complaint. So the timeline is very, very important in this regard. Otherwise the women voice will not be heard and she will be again in a deep dilemma of even a depression. She can be a victim of depression also, that her voice is not being heard. So that is why the timeline is mentioned here, that is the 7 working days from which the report has been submitted by a woman. The first meeting of the internal complaint committee must be held, in which a detailed incidence is reported, that what happened, why happened, where happened, who is a victim, who is a complainant, who is a complainee, and what happened, whether the incidence is very, very grave, or even the verbal warning could be enough as a redressal for the sexual harassment which has already been done at the workplace. Now the internal complaint committee must verify and must investigate the complaint, and this kind of investigation, this kind of finding out, fact finding is very, very important in this regard, because this report has to be submitted, which includes the finding and recommendations along with the relevant documents, because sometimes, as I said, that the women is having a malicious intention also. The incident never happened, but the women, because of her own personal settlement of certain scores with someone, she is reporting a wrong incidence in the organization. So that aspect and that issue must also be addressed, and that issue is very important to understand also. Now coming it to the further aspects of it, that once the incidence is reported, within next 7 working days, the first meeting of the internal complaint committee must be held, wherein all the members are informed about the incidents, and the first meeting will have a detailed reporting of the event. Now is the time for the internal complaint committee to have a detailed investigation and the reporting aspect. So investigation is very, very important. The investigation must be detailed, it must be done in depth, it must be impartial, and whatever are the incidents which are collected, the information which is collected in this regard must be reported in a particular format which gives you a complete information about the incidents, about the time of the incidents, about what type of sexual harassment act has been done, and of course where it happened, how it happened, who are involved. So all the minor details as far as the reporting part of it is concerned must be given in writing by the internal complaint committee after the detailed investigation has already been done. Now after conducting an inquiry, a minimum of 3 members of complaint committee, including a chairperson, to be present. So when the inquiry has to be done, there's a quorum which is mentioned here, that is the 3 members who are a part of the internal complaint committee, including the chairperson, they must be present in that meeting where the reporting has to be done. Now, upon the receipt of a complaint, they review the complaint to ensure that it has all the information. The conduct of respondent was towards the complaint and is improper and may be from the sexual harassment at workplace. The incident occurred in the workplace or any other location, any event related to work. They have to send the complaint to a respondent within the 7 days of receipt to respond within 10 days. They have to meet up the complainant for any settlement and reconciliation. Now, after the complaint has been registered by a woman and upon receipt of the complaint, now is the time to review the complaint. Why the complaint has to be reviewed? First, to ensure that the complaint has a complete information. Number 2, the conduct of the respondent was towards the complainant and improper, may be a sexual harassment at workplace. Now, of course, you have to send the complainant to a respondent within the 7 days of the receipt of the respond within the 10 days. They have to meet up the complainant for any settlement. Now, as I said, once the complaint has been registered, within next 7 working days, the meeting is held, wherein all the members are informed about the incidents, how it happened, where it happened, who is the complainant, who is the complainee. The detailed aspects of the sexual harassment as workplace is discussed in that meeting. Now, after the detailed discussion, the matter is sent to the person who has done the sexual harassment, has been asked to report within 10 days. Now, after collecting detailed information, the complaint committee must ensure that they must meet up the complainant. So, once they call the complainant, they must deeply inquire about the incidents, that why this happened. Does it actually happen, or you are also a victim of a malicious complaints? Because the complaint committee cannot work in imbalance. They cannot have a lopsided approach. They have to listen to both sides, that is the complainee also and the complainant also. Once they are satisfied in relation to the information which has been collected by them, now is the time for the reconciliation. If they accept that yes, we are, we did this, then of course the matter is resolved there and then, in terms of either explaining them by taking care of certain sessions with them, by verbal warning to them, by fine with them, or taking it to the court also in certain cases, because it is a civil and a criminal liable offence, which that is the sexual harassment at workplace. But in most of the cases, it differs from case to case, the punishment. The imprisonment also differs from case to case. Sometimes the redressal is only a verbal communication to them that in case this incidents happen, we will do this. You have to leave the job, you have to resign from the job, or maybe you have to be expelled. You will be facing the expulsion of the job, that is, you will not be anymore allowed to come in that organization for that matter. Now is a time for the reconciliation also. Sometimes the complainant and complainee, they sit together with the internal complaint committee. A detailed discussion and reporting is done therein, wherein the matter is reported and the efforts are being set for the reconciliation also. So this conciliation process, it starts from initiation of conciliation process in the form of verbal warning, counseling, educating, appoint neutral conciliator to resolve, forward the findings, conciliation resolution to the employer, and of course the choice is of the complainant. Now, which redressal has to be followed? Whether the complainant is happy with the verbal warning also. It could be after the good sessions of counseling, the person changes himself, or he understands that what he has done is wrong, and he gives the assurance that in future these acts will not be repeated, followed by educating him that the offence which you are into is so serious that you might have to quit from your job. And of course, you have to appoint a neutral conciliators to resolve this kind of an issue, because if the conciliator is biased, nothing can happen. no solution can take place, and of course everything which you do is definitely influenced by a biased opinion, which is definitely not good in the most of the organizations. Now, taking it forward, the Internal Complaint Committee will inquire about the issues. Now, the inquiry is concentration of, that is to initiate the inquiry, the interview, the complainant, respondent, witness, listing of the events, the fact finding, confidentiality and impartiality is the key. Now, it is the job of the Internal Complaint Committee to do the inquiry in deep. Now, doing an inquiry in deep involves you have to interview both the complainee and the complainant. You have to do in detail about the witness, that is whosoever, if there is any witness, you have to even talk to them in deep, that what happened in terms of the incidents which provoked an individual to go in for a sexual harassment acts. Then you have to, as a matter of fact, they have to list the events in the sequence of how it happened, where it happened, who's responsible, who was wrong, who was right, and a fact-finding committee is complete in this regard, because the members of the Internal Complaint Committee are so responsible. They are so deeply involved in the investigation, because nowadays we are living in a matter of RTI Act, so which empowers everyone to find out a complete information about what happened, where happened, and how it happened. And in this case, the fact-finding, confidentiality and impartiality is maintained to the deep extent. If the matter is not kept confidential, it can have a very serious repercussion in terms of not taking a right judgment, and the people who are not into a kind of a right judgment can have a serious repercussion on the working of the organization also. The people will be left out to repeat those malicious acts, bad acts and the sexual acts. So that is why the reporting items, the detailed investigations have to be under a complete cover, and they must be uncovered when the investigation is complete and the person is found guilty. And if the reporting items or the information and confidentiality is not maintained in the beginning, then of course the judgment cannot be right. And of course, one of the key factor for this Internal Complaint Committee in terms of the inquiry is that you always have to be impartial in your approach. In terms of the impartiality is not there, then the results could be bad, the repercussions are negative, and there is a negative spillover of the organization to the other people also. Now coming on to the inquiry process. They must follow the principles of natural justice. They must order ex parte or terminate the proceedings if the complainant or respondent fail to be present for 3 consecutive hearings. The legal practitioners are not permitted and the confidentiality has to be maintained. So a detailed, complete inquiry process has to be in order. The natural justice principle has to be followed, and you have to follow the proceedings, and you cannot be absent consecutively for 3 hearings which this committee orders you to come. And in the whole process, the confidentiality has to be maintained in the order. The committee must adhere to the rules of the natural justice. There are 3 important rules to be observed by the committee: hearing, play fair, and reasoned orders. So taking it forward, if you are not following the rules of the natural justice, you cannot do justice to the people who are a victim of the sexual harassment at workplace. So whatever you do, you must follow the natural rules of the natural justice. That is, whatever decisions are taken, they must be backed by the evidences. They must be backed by the overall the facts which have been revealed by the fact finding. So hearing, nobody can be condemned without being heard. So hearing is very, very important from both the parties, the party who is a victim and the party who did it. A complete hearing can also give you very deep insights about the incidents, about its happenings, about what happened, where happened, etc. And only then you will be able to play fair in this regard, because unless and until you hear both the parties, the judgment would be impartial, it could be lopsided. And of course then you can pass on the interim orders also, the reasoned orders also. Now coming on to the interim measure. To prevent the ongoing sexual harassment at the written request of the women or even otherwise, the complaint committee may recommend restrain the respondent from reporting on workplace of the aggrieved women, writing her confidential report appraisal, supervising her academic activities, transfer the complainant or respondents, place complainant or respond on leave. Now sometimes the matters are such that the interim measures are provided for the incidents which are relating to sexual harassment at workplace. Now to prevent this ongoing sexual harassment at workplace, the complaint committee which is there and is a custodian of these events at the workplace, they may recommend restrain the respondent from, like the person who is already into a sexual harassment act, that person may not be allowed to come to the organization where that aggrieved women is there. This is one of the shortest and the fastest relief and measure which the sexual harassment committee, that is the internal complaint committee, can offer to the aggrieved women, that that person is prohibited to join that office again or come to that premises in which the aggrieved woman is there. Followed by reporting on the work performance of the aggrieved women, in this case writing her confidentiality report appraisal, supervising her academic activities, transfer the complainant or respondent. This is another redressal which is allowed here, that the person who is responsible for sexual harassment at workplace, they may be transferred from that particular place, or the respondent may have to leave for some, and sometimes they are supposed to go on for a forced leave, and unless and until the fact finding is complete, the reporting incidents are complete, they are not allowed to join that organization again, because the aggrieved women is there. Again the incidents can trigger, again the problems can be there, again the situation could be chaotic. So these are the reasonable measures, the interim measures which that complaint committee can give them, that is restraining that person to come and join that office again, or asking them to go in for a forced leave till the time the fact finding is complete, followed by a transfer of the complainant or a respondent is a very good relief, an interim relief which the internal complaint committee can give to a women. So now coming on to the recommendations, in case the allegations are proven, so that means that person is actually into a very wrong act. So these are the redressal which are in front of you. In case the allegations are proven, the service rules to be followed for the misconduct, the disciplinary actions can take. The disciplinary action can be in relation to a written apology, warning, reprimand, withholding of promotion, withholding of any rise in the pay scales, increments, counseling sessions, termination, financial damages, additional recommendations to address the underlying factors. So if you see the complaint analysis of the sexual harassment at workplace, that what is the meaning of sexual harassment, what is a aggrieved woman, what is a workplace, what are the acts which can be called as a sexual harassment at workplace. So we have done all that in detail. We did all the sections which are related to the Vishakha Guidelines here. Now we are coming on to the final and the last part of my the lecture, that is the recommendations. That is, after the deep inquiry of the internal complaint committee which has been proved at the workplace, these are the immediate measures which can be recommended by the internal complaint committee. It could be if the service conditions are proved in terms of the misconduct, sometimes the redressal could be a written apology only, because nowadays if the people are very afraid of putting everything in black and white, if that person is ready to give his written complaint, written apologies to the aggrieved women, and the aggrieved women choice is there also in this regard, or she accepts that the written apology is enough for her, then we must take this as a redressal, and of course the actions are taken. and sometimes the warning is given to them. In case of the warning, that in case the incidents are repeated, the people who are responsible for the sexual harassment at workplace, they can be out of their job immediately. And sometimes if the people are due for their promotions or rise in their financial emoluments, so we can stop them. We can terminate their services, and sometimes the financial damages can be asked from them, and the additional recommendations could be the underlying factors which are responsible for this. Sometimes there is a false complaint. We must see and lift the veil, because sometimes the law which is in favor of women can also be against her, and overall the women should also not be using this tool for settling their personal scores, for destroying the working of the organization. If the incidents actually happened, then only they should complain, and they should give a written complaint to the Internal Complaint Committee, because this is all a legal thing which is in play. It is not a joke, because this is a quasi-judicial body, and every woman must understand that the rules are for their favor, not to solve their malicious intentions. So all the people who are involved in this network must give their fair opinion, judgment, so that if actually the sexual harassment has taken place in this regard, then a right to preventive action can be taken against them, disciplinary action can be taken against them. It should not be any kind of a malicious incidents which should be there. Now coming on to the timelines, the submission of the complaint has to be within 3 months of the last incidents. The notice to the respondent must be given within 7 days of receiving a copy of the complaint. The completion of inquiry must be done within 90 days of the complaint. Submission of the report by the Internal Complaint Committee, Local Complaint Committee, Director's Office must be given within 10 days of the completion of the inquiry, and the implementation of the recommendations must be given after 60 days within 90 days of the recommendations which has been issued by this Internal Complaint Committee. So this timeline is very, very important, that once the complaint is registered, that complaint, giving and registration of the complaint must be within 3 months of the reporting of the incidents, followed by, once you report it to the Internal Complaint Committee, within 7 days the first meeting must be held, and after they start inquiring, within 90 days they have to complete the inquiry. That is basically 3 months, and after they give and submit the report, within 10 days of completion of the inquiry, they have to submit the report. And of course, within 60 days and within 90 days of the recommendations, there should be implementation of the entire confidentialities. Now coming on to what is the basic concepts of confidentiality. The Act prohibits the disclosure of the contents of the complaint, identify and address the complaint, respondent and witness, information pertaining to conciliatory inquiry proceedings or recommendations of the Internal Complaint Committee / Local Complaint Committee, actions taken by the employer or the director office. The consequences is that, as per the service rules, 5,000 to be collected by the employer. Now coming on to the last section, that is the monitoring. The whole process is called as a monitoring process under section 5 of the Vishakha Guidelines. Submission of the annual report. You have to give the number of cases which has been reported, the number of cases which has been disposed of, the number of case pending more than 90 days, the number of workshops, awareness sessions carried out, the nature of action taken by the employer, inspection, make available any information, record or document including the physical inspection of the workplace, and you have to mention in the director's report. Now these are so important that the non-compliance can give you the penal consequences, that is the penalty of 50,000 Indian INR where the employer fails to constitute a complaint committee, fails to act upon the complaint committee's recommendations, fails to file the annual report, and contravenes or abets the contravention of the provisions of the Act, and in the case of the event of repeat of the breach, twice or higher the punishment prescribed, cancellation, withdrawal, non-withdrawal of license, registration for carrying out the business. So you have to understand that this is all legal and we must comply non-compliance is very, very bad, and it is the fine is so important to be paid, which makes 10 to 50,000. And a person aggrieved by the orders of the complaint committee, or in case of the non-implementation of the orders, may file appeal with appropriate authority. Either the party can choose to seek justice through the regular court of the justice. And coming on to the last part, that is a summary of today's lecture. We must make sure that there is a policy that has been effectively communicated to all the workers, irrespective of whether they are paid or volunteers. Display detail of both formal and informal ways of available to a worker to address complaint about the workplace sexual harassment. They must undertake the orientation on workplace sexual harassment of all the orders in respect of the organizations, establishment or institutions. The complaint committee, which is trained in terms of the skill and capacity, is critical for building the trust of the people. They must encourage the senior persons, leaders, supervisors who can influence the employment related decision to become the role models. The men and women should be included in building a culture where no tolerance, no longer workplace sexual harassment is tolerated. So we have to make a no tolerance zone with the help of all the seniors and the people who are on the payrolls of the organizations. The seniors can play a very pivotal role to control all these incidents because of their experience, because of their advice to the young people, so that we have a place where there is no place for sexual harassment at workplace. So with these words, I end my lecture. Thank you so much.
Thank you, ma'am. Thank you so very much. And dear friends, do write to us at info.cec@nic.in if you have any queries, and keep watching the lectures on the YouTube, as the lectures pertaining to the series Organization Behavior are there for you. We will be meeting again soon. Till then, take care. Goodbye. Thank you, ma'am. Thank you once again.